Today I'm going to be giving a brief introduction or talk on the legal environment of HR, or the legal environment for personnel selection. You'll notice as I go through, I'm going to skip some slides just because of time. However, I'll leave those slides in so that if you wish, you can always go back and freeze on those slides and read through or take a look at those slides. But you'll also notice I'm skipping slides just because of time. Okay, we're going to start by talking about the laws in the United States. It's helpful to understand this. We, of course, are not going to talk about any other countries' laws. We're not going to talk about Canada. We're not going to talk about Europe. We're not going to talk about Australia. We're going to limit ourselves to the United States because that's what I know and that's what we're mainly concerned with. In the United States, what we have to always remember is there's no right to a job or work. And the employer may really use anything they want to make a personnel decision until or unless it violates some law. Of course, the usual law that their employment decision might violate, or that we would be considered with, is some type of civil rights legislation. Also, of course, the principle of employment at will underlies employment and employment decisions in the United States. Employers and employees have the right to initiate and terminate the employment relationship at any time for any or no reason at all. Usually, of course, we would hope that termination would be based on good, sound reasons, but it doesn't have to be. Employers value employment at will because it reduces necessary documentation and work defending termination. However, we should note that due to recent employment cases about wrongful discharge, many companies and states have incorporated just cause discharge policies. Just cause means you have to fire someone for acceptable reasons. Also, you can sometimes make a tort claim. That is, you'll sometimes see people who are fired argue that there was some type of contract, either explicit or implicit, and their firing violated that explicit or implicit contract. All right, so what are some of the laws we have to be concerned with? Well, the major laws we have to be concerned with as HR or personnel selection specialists are the Civil Rights Act of 1964 and 1991, the Age Discrimination Employment Act of 1967, the American with Disabilities Act of 1990, that was amended in 2009, the ADAA, or the Americans with Disabilities Act Amendment Act. And then there's, of course, all other laws, such as the Equal Pay Act of 1963. That becomes important when discussing compensation or pay, and various state laws. There are also laws that relate to education. Now, education, of course, is different from employment. Although, there was recently an affirmative action case involving education that impacted employment. So there are education laws, but technically, of course, education laws relate to education, not to employment. Okay, so let's go back to discussing civil rights and equal employment opportunity, especially the concept of civil rights. We might ask, why do we need a Civil Rights Act? Well, the argument for why we needed a Civil Rights Act was that it related to a general sense of fairness and fair play. Also, when it was passed back in 1964, it was intended to eliminate the large economic disparities that existed between different races or ethnic groups. Now, of course, most of you, or all of you, none of you maybe were alive back before 1964. I was born in 1954. But before 1964, it was, of course, legal to have jobs that were segregated by both race and sex. So often dual tracks existed. For example, you would have African-American janitors and white janitors. And the white janitors could receive different pay and could get promoted into jobs that African-American janitors could not. So you see on the right-hand side of this slide some examples of ads that you might have found back prior to 1964. Housework, white girl for general housework at shore. Maid, white. So this was legal prior to 1964 to segregate jobs by race and sex. Of course, the Civil Rights Act then passed or went into effect in 1964. This is Lyndon Johnson signing the Civil Rights Act. The Civil Rights Act has been amended on a number of occasions, including most recently, or at least a major amendment in 1991. It covers discrimination, including by employers in personnel actions, and it prohibits discrimination on the basis of race, color, religion, sex, and national origin. Note, age is not included in there, and neither is disability. The Civil Rights Act designates certain racial groups. The racial groups designated are American Indian, Alaska Native, Asian or Pacific Islander, African American, white, and Hispanic. Of course, without going into a lot of detail right now, this is much more complicated now due to the adding in of additional groups, the splitting off of Hispanic from the other racial groups, the inclusion of maybe perhaps country of origin. It's become more complicated, but historically, these were the groups. And we might note that the one group that can be discriminated in favor of is American Indian, Alaska Native. And that's because there exist certain treaties between the United States and Native American groups that allow for the discrimination in favor of those groups. So the one group that can be discriminated in favor of is American Indian, Alaska Native. None of the other groups can be discriminated in favor of, and of course there can be racial discrimination against whites. Sex was a late addition to the Civil Rights Act. I'm not going to spend a lot of time. It's very interesting, but I'm not going to spend a lot of time covering it. Why it was a late addition? Its late addition did cause a variety of problems. Perhaps one of the most famous amendments for us in the Civil Rights Act was what was called the Tower Amendment. The Tower Amendment specifically said that professionally developed employment tests can be used. Of course, this amendment later was attacked, revised, changed. All sorts of things happened to this amendment. But Congress gave thought to the fact that perhaps the Civil Rights Act could be seen as prohibiting the use of professionally developed employment tests. So they specifically put in an amendment that said professionally developed employment tests could be used. We might note the Civil Rights Act does not require rational decisions, although we would certainly argue that rational decisions should be made. Its major concern is the identification and elimination of race and sex discrimination, and race and sex information is collected through self-identification. The Civil Rights Act also, there's no requirement that the workforce be race balanced. As a matter of fact, any deliberate attempt would be reverse discrimination. And the Civil Rights Act of 1991 specifically prohibits race norming and other score adjustments. This just explains who the Title VII of the Civil Rights Act applies to. It applies to employers larger than a certain size. There are some exceptions. Those exceptions include Native American tribes, private nonprofit organizations, and religious groups. Title VII does not apply to three types of employers. Federal government, at one time, that's no longer true. Religious groups performing work connected to the group's activities, including associated education institutions, and bona fide nonprofit private membership organizations. This just goes through what a nonprofit is. There's been court cases that deal with the question of membership groups and nonprofits. And so, it's just a legal issue, what defines a nonprofit. A religion is included in the Civil Rights Act, but Its protection is somewhat muted by the First Amendment. Most of the cases you tend to see involve retail sales where there's often an issue of Saturday or Sunday work. There is something called the ministerial exception. There's been court cases related to this. This relates to whether someone is really performing religious duties on their job. It's a fine point. It's interesting. Feel free to stop and look at the slides, but we're not going to cover it right now and here. Civil Rights Act, of course, does not cover age. The Age Discrimination in Employment Act was enacted in 1967. It's important to remember that age is not covered by the Civil Rights Act. There's been then a continuing debate as to whether adverse impact arguments can be made under the Age Discrimination in Employment Act. That's a very interesting area of the law. We're not going to be able to cover that in depth in here, but it does influence things like physical cutoffs or cutoffs on physical ability tests. Okay, there's a number of regulatory agencies you should be familiar with. The main regulatory agencies are the EOC, or Equal Employment Opportunity Commission, the OFCCP, or the Office of Federal Contract Compliance Programs, and of course, many states have fair employment commissions. And finally, the Civil Rights Act can always be enforced through any individual filing a lawsuit. Again, here's our main regulatory agencies, the EOC, the OFCCP, or Office of Federal Contract Compliant Programs, and the Department of Justice. And then the states have various fair employment commissions. A simplistic view of what these cover or what their coverage areas are would be the EOC covers all private organizations. The OFCCP covers all private organizations that receive money from the federal government, whether it be grants or contracts. And the Department of Justice covers states and cities, covers government agencies. The EOC then deals with violations of Title VII of the Civil Rights Act. It processes complaints of discrimination. And of course, it's responsible for what has had a huge influence on IO psychology, the Uniform Guidelines. Again, the OFCCP, Office of Federal Contract Compliance Programs, deals with federal contractors. They enforce executive orders. They're closely identified with the idea of affirmative action and the development for federal contractors of affirmative action programs. What is affirmative action, you might ask? Well, these are procedures which attempt to increase the representation of an underrepresented protected group. The OFCCP actually has a list of factors for determining underrepresentation. They are listed here. Okay, we're now going to move into the various theories of discrimination. It's very important that as an IO psychologist, you be familiar with these various theories of discrimination. We can think of there as being 6 legal pitfalls that an organization can run into. Those 6 legal pitfalls would be intentional discrimination, adverse impact, a failure to accommodate, an invasion of privacy, negligent hiring, and retaliation. We're going to talk about these. Okay, in terms of theories of discrimination, though, the major theories of discrimination are disparate treatment direct, disparate treatment indirect, disparate impact adverse impact, and then pattern and practice or across the board cases. What is disparate treatment direct? Disparate treatment direct is what we think of as intentional discrimination. It's where there's differences in decision making based on a person's protected status. For example, we might have a job opening, and when people come in, we ask them some questions in an interview. If it seems like they can't speak English, we then have them take an English language test. So only one group is required to take a test, individuals who we see as not being able to speak English, which of course could also be influenced by race or sex. Also, another example would be denying access to training based on sex or race. For example, we might have a job in the Middle East, and we might say, well, companies in the Middle East don't want to deal with women or females, and so we're not going to provide training on dealing with customers in the Middle East to anyone who's a female. So disparate treatment direct usually involves some type of smoking gun. For example, a specific statement. We did not promote them because of their race. Then there's disparate treatment indirect. Here we do not have a smoking gun. Instead, the evidence is indirect, and it's based on the case made through the evidence. And the most famous case here is McDonnell Douglas v. Green, 1973, which you can look up in Wikipedia if you would like. So disparate treatment, McDonnell Douglas v. Green, 1973. This case argues that to prove or to make a case for indirect discrimination, the plaintiff, and the plaintiff would be the person suing, the minority person, or we'll use minority here to refer to both race and sex. The minority person suing is trying to make an initial claim, and we call that a prima facie or prima facie claim. If they make this claim successfully, then the case moves on to later stages. So they have to make this initial prima facie or prima facie case. So under McDonnell Douglas v. Green, what do you have to do to make a prima facie case? You have to first belong to a protected class. You have to second apply for a job and be qualified. You have to third be rejected. And then fourth, the position has to stay open or be filled by someone of another race that is less qualified. So that's how, under McDonnell Douglas v. Green, you make a prima facie case of indirect disparate treatment. After the prima facie case, the burden of proof, and we won't get into a long discussion of whether it's burden of proof or burden of persuasion or what exactly the burden is, but the burden falls to the company or the employer then to make a productive defense. That is, the company or the employer has to articulate a legitimate reason for their decision. Of course, at that point, the plaintiff's attorney, the plaintiff, would probably argue that that legitimate reason was a pretext. And so that's usually what the court case involves. Is the defense, in fact, a legitimate reason, or is it a pretext? Please note that what we usually call adverse impact information can be used as part of the establishment of circumstantial evidence in a disparate treatment case. So even though this is a disparate treatment case, you can still bring adverse impact information in, although it has a different role. In a disparate treatment case, the role of adverse impact would be to serve as circumstantial evidence. A pattern and practice case. This is another type of case. Some people would argue it's really just a disparate treatment case. But in a pattern and practice case, the approach is that the plaintiffs need not prove any individual case to prevail on a pattern and practice disparate treatment claim. So this is a case where the group as a whole presents evidence of discrimination, even though the discrimination is still disparate treatment against particular individuals. Okay, there are, of course, some other ways to sort of involve, there are some other arguments or methods by which we could make a disparate treatment case. For example, the interview. There are certain questions that could be asked in the interview that could be seen on the face as being discriminatory. That is, as being based on race, sex, or other. Like a common question in the interview that could be seen on its face as being discriminatory is asking women if they're considering getting pregnant. Now, some states have a specific list of questions that are deemed to be illegal questions. Okay, BFOQ. You know, when you give talks, people love to talk about BFOQs. They're an exception, they're very rare, but people find BFOQ cases to be extremely interesting. So even though they're an exception and very rare, people find them to be very interesting. But realistically, for most jobs, BFOQ cases are not likely, are not really possible. Where might we see BFOQ cases? Well, for example, female guards for female offenders. An argument could be made that female offenders have a right to privacy, therefore the individuals we hire to guard female offenders have to be female. A men's restroom. You could argue that with a men's restroom, you have to have a male attendant. A common argument is plays or theater or movies. That for a play or theater or movie, you have to have a male to play a male character, a female to play a female character, a woman to play Joan of Arc, a tall man to play Abraham Lincoln, a tall man with a beard to play Abraham Lincoln. And perhaps the most famous BFOQ cases have involved Hooters. And, you know, again, undergraduates tend to get really interested in BFOQ cases like the Hooters case. A note, simple customer preference, for example, feeling more relaxed if I hear a female voice, or customers thinking they prefer a really tall, burly police officer. Simple customer preferences are not considered BFOQs. Okay, we move forward to disparate impact, so we'll start speaking about disparate impact. Disparate impact. A disparate impact case involves a neutral device that results in adverse impact toward a protected group. And in order to make your case, then the neutral device has to be non-job related. Important to the concept of adverse impact is this idea of adverse impact. And adverse impact is a significant difference in hiring rates, or I mean, it could be the rates of any kind of employment decision. We'll talk about hiring rates here, but it could be promotion rates, layoff rates, any kind of hiring decision. And of course, even though the device, usually a test or assessment, is shown to have adverse impact, the organization can, in rebuttal, still show the device to be job related. The most famous disparate impact case is Griggs versus Duke Power from 1971. Okay, so how does a disparate impact case proceed? Well, usually it's up to the plaintiff to start by demonstrating, again, a prima facie case. To demonstrate a prima facie case, the plaintiff must show adverse impact. At that point, the company would respond with proof that the test is job-related or business necessity. The plaintiff would then argue the test was not valid. The company would argue the test is valid. The plaintiff would then argue the test has differential validity. The company or organization or employer would argue it doesn't have differential validity. The plaintiff would then argue the test is biased. The employer would argue it's not biased. The plaintiff would argue the test has no utility. The organization would argue it does have a utility. And finally, the plaintiff would say there's equally valid alternatives that exist with less adverse impact. And the company would say, no, there's not. Usually, actually, there's really, it comes down to three prongs, though. They usually talk about the three prongs of a disparate impact case, and that would be adverse impact, validity, and then alternative devices. So just going back and reviewing again, we've seen there's three different types or three different theories of discrimination. We get a disparate treatment direct, disparate treatment indirect, or disparate impact, adverse impact. Again, if you have any questions, please feel free to bring them to one of the next office hours or to ask the instructor. Okay, some other laws. There's the ADA of 1990. Despite revisions or an amendment to this act, it's still difficult to know exactly how to interpret this act. It's aimed at individuals, not groups. And the basic, though, idea is that companies need to make reasonable accommodations. In 2008-2009, the ADA Restoration Act was passed, or what's called the Americans with Disabilities Act Amendments Act. And this mandated a broader construction of the ADA in order to ensure that the ADA achieves its purpose of providing a comprehensive prohibition of discrimination on the basis of disability. Okay, some other acts, there's other laws or acts that are relevant. We don't have time to really spend a lot of time on them. There's the Family and Medical Leave Act. There's the Fair Credit Reporting Act and Fair and Accurate. There's the Credit Transactions Act, and there's the Employee Polygraph Act. The Ledbetter Act. Most of you are too young to remember probably when Obama ran for president, but a big part of Obama's presidential campaign was actually the Ledbetter case or the Ledbetter Act. But the main thing that the Ledbetter case or act did was to increase the window for filing claims. So normally when you are aggrieved or injured, you have a certain amount of time to file your complaint. The Ledbetter Act made it easier to file claims about acts that had occurred at much longer times in the past. Of course, we also have to be concerned with unions. Both in the private and public sector, unions exist, and those unions can have an impact on the assessment devices that we use. Public employers also have to worry about privacy-related requirements of the U.S. Constitution. As such, tests administered to public employees must not be unreasonably intrusive and must be job-related. Some other court cases, a famous court case is Connecticut v. Teal. This is a bottom line case. This case still, when you think about it, it doesn't make a lot of sense in some ways. What happened in the case was, or the basic idea, I'll just say the basic idea of the case. The basic idea is many organizations feel or argue, well, if I don't have adverse impact overall, then I shouldn't have to defend the different parts of my selection system. But the Connecticut v. Teal case says that even if you have a non-discriminatory bottom line, a plaintiff can still attack different parts of your system and argue that those different parts of your system have adverse impact, are not valid, and therefore resulted in discrimination. Guardians v. New York. This is a very important case, I believe. It's often, I think other people tend to not put enough importance on it. Uh, but the important thing about guardians was that it distilled from the Uniform Guidelines 5 basic principles. And the 5 basic principles that it distilled were that to have a valid test, you had to have 1, a suitable job analysis, 2, show reasonable competence in constructing the test, 3, show that the content of the test is job related, 4, show that the content of the test is representative of the job, and 5, show that you have a scoring system that results in the selection of better performers. Yeah, there's been a recent, of course, important adverse impact case, which a lot of people are looking on as limiting the ability of organizations to use adverse impact. But probably the first critical adverse impact case was Regents v. Bakke, which involved a medical school in California. Some other recent laws and court cases, probably one of the most important is the Ricci or Ricky case. Different people pronounce this differently, but Ricky v. Di Stefano. This was a case that was brought by white and Hispanic firefighters. There was a test that was given. It was thrown out by the city of New Haven, Connecticut, because the city argued the test was biased against African Americans. However, then the whites and Hispanics sued, arguing that the test was not biased against African Americans, or at least that the city hadn't proved that. And the Supreme Court, ended up agreeing with the white and Hispanic firefighter plaintiffs. Some of the implications of this decision would be that it could be seen as easier to validate tests. It could be seen as harder to throw tests out just because that had adverse impact. And it could be seen as somewhat harder to do various kinds of post-test adjustments to scores. Howe v. City of Akron. This is a very interesting case because it involved the use of almost exactly the same test. Almost exactly the same test was used at the lieutenant and captain level. And yet, for the lieutenant test, there was found to be unlawful discrimination against African Americans. For the captain test, there was found to be unlawful discrimination against whites. And both tests were found to unlawfully discriminate on the basis of age. So a very unusual case in that the same test was found to discriminate both against African Americans at one level, the lieutenant test, and against whites at the level of the captain test. The Coronis case. The Coronis case is a case, I'm not even sure what happened to it. The main reason this is important is because it involved personality tests. And I think if the main takeaway would be that personality tests are still subject to the same principles of the Uniform Guidelines, the same principles of adverse impact and validation as any other kind of test. Okay, one of the concerns that's come up recently, of course, is vetting people on social media. And although, it's somewhat surprising with the advent of AI, you see less about vetting people through social media. But, within probably the last 10 years, this has been a major concern of people.